Hello, people! It is I again, and I'm here to give some information. I found a rather good little, I don't know, SoundCloud podcast, whatever you want to call it, by the Judiciary of England and Wales. And they go into some detail here about the separation of powers, how obviously you don't want a despotism in a government or a state, and particularly within England, obviously, and the UK government, there's been an established practice of separating out the powers from the executive, the legislature, and obviously the judiciary. And the reason is you don't have these branches really working in cahoots too much. Obviously they work cooperatively, but essentially they work very much on a separate basis in order to keep each other in check. You know, disagreements, arguments are all good in a healthy running democratic system where there is a separation of power. And here I came across this thing about the rule of law. Now, the rule of law is a very, very multi-meaning kind of phrase, and the dictionary definition here is quite simplified. Literally, the collection of rules imposed by authority. So by having an authority over someone, they're allowed to impose certain rules of that, and it says here, society. And the established customary state, especially of society, a society, the society, some sort of society, order ruled on the streets, law and order. So you're looking at law, order, order as opposed to chaos. So then I would also bring into that, you have the peace, the Queen's peace, the King's peace, the peace of the realm, the peace of the land, whatever you want to call it, peace and quiet, as opposed to a state of war, conflict. So that all kind of builds into that. And there's also, if you look in the legal definition, there is a whole swathe of like jurisprudence about what the law or the rule of law actually is. And there's a religious context to it, as in the idea of, God and your right as a man, and how the laws are essentially a gift, or the judiciary in particular should pay due diligence to what these laws are and where they've come from, and how, as man on planet Earth, should interpret, obviously, as a Judeo-Christian culture and customs that are within the Commonwealth, wherever you may be. So, the idea is that, the individual is sovereign. Now, that's nothing unusual by saying that. I'm not getting too religious or anything like that. But essentially, the individual has to be respected as a sovereign individual, i.e. they have all the right, no one is above the law. We're all equal under the law. The king is not even above the law. And this is where, the certain regard for persons are not, an issue for a judiciary. Just because you're the king or a peasant, if the king goes up and assaults a peasant, the peasant's just as entitled, or has just as much right to recompense as the king would be should something happen to the king, or whoever is the man who acts as the king, and the man who acts as the peasant, or the pauper, or the homeless guy. So that's the idea. It's a great leveling, and it's a really good cornerstone of the Western democratic system, is that all are equal under the law. It doesn't matter how high you are on your own horse. You do someone wrong, you're a debtor, and once you've done someone wrong, you better take action to repay that debt of your own free will, your own volition. And if you don't do that, then obviously you contact that person and seek payment of debt for wrong or harms done, damages. And if then they don't respond to you as they should do, then the only alternative then is to seek justice from the court system and the judiciary, and to have that then enforced through the systems of government that operate in your territory, or your state, your land, whatever you want to call it. So that's basically it. But I can't go through all of these rule of laws, but this is the free legal dictionary online, and they have some good insight into the rule of law, and the various different interpretations based on who's writing it, obviously. Now you pick the one that suits your jurisprudence, your particular belief system in relation to into how you believe the law should be interpreted. The Aristotle one here is quite good at the bend. Absence of arbitrary power, equality before the law, and the liberty and constitutional law generally, as a result of the law and laws made in the courts. Now that's referring to the common law. Okay, so this is how the common law of England, or the legal society, or the government. The common law of the government is a way of probably simplifying it so people get the difference between the common law, or what it's referred to in England is almost like the law of the land. So the law of the land being people, yes, this is a way of what's the law of the people? What do the people believe is customary or acceptable within their society? And hence we have juries, okay, particularly in criminal cases, for some reason not in civil cases, because obviously civil being a Roman code thing, juries are not required or needed or a guarantee, but you can obviously have them in if you in the true sense of the law of the land, and that's a good way of people judging people on their actions, yeah, where as opposed to an arbitrary judge or magistrate, if you like, just laying down what their beliefs are and perhaps being influenced by their position and their associations. So that's basically where it all comes down to. It's a really good concept and quite a big rabbit hole to go down, and I'd recommend you all get your head around the rule of law and what it means to you, which definition. There's lots of wide reading on any old legal book, because the rule of law is pretty much established even within the legal realms of what it is, and I'd recommend that you all go and have a little read of it. Now we're going to go back to this. So now that we've got that kind of prelude to what's going on here, well, listen to this audio. Now the audio is 4 minutes 33 seconds, but it's really, I just like the way it's presented, and the facts in here are very straightforward, very simple for people like me and you to understand, and the guy speaks very calmly and goes through it, and they make some interesting points or some statements about what we, in this case the citizen, can expect from the judiciary, and how it should function to benefit not only the government but also the citizenry, i.e. in its simplest form, the people.
The term democratic state under the rule of law means a state where citizens elect their own leaders. State
being an agreed territory. Okay, so state is, as been explained many times, state it's so amorphous in terms of what it can relate to. And now he's talking about a state where we elect our leaders. So what happens if you don't wish to elect a leader? Are you forced to elect a leader? What happens if you don't wish to be led, if you like, in a democratic system? Do you have no choice? It's one way or the highway?
A state where government itself is bound by the law and helps ensure that the law is respected in the relations between citizens. The law guarantees everyone's individual freedoms against contraventions by government or by other citizens.
Contraventions? So how would the government contravene a law? If they're writing the law, how do they contravene a law? Isn't that an oxymoron, if they're the legislature? So is it possible then, by that statement, that they're saying that the government can break the law, does break the law, will break the law, and therefore there is, by that statement, a means to which the citizen can have access to justice and redress of grievances, is the common phrase that's pouted around.
This can only happen if the legislature, executive and judiciary are separate, and a crucial element is an independent court system which is truly accessible to the citizen.
Now, when you first said truly accessible to the citizen, I burst out laughing, because I thought, yeah, really. When I go down to my public courthouses and no one really wants to help you bring your own case to court, whether I go into a criminal court, a magistrate's court, a crown court. The Crown Court has been the best in terms of customer service and the most helpful and the most obliging. The Magistrates' Court deal with the riffraff of society, so they're basically got a thick-skinned barrier up while you go in there. But they're quite helpful, but they won't help you get your indictments done or they won't help you bring a criminal case to court. Well, they try, but they always say seek legal advice, and that's essentially the realm of the criminal courts. Is you pretty much need to seek criminal advice to dance in that arena. You're not qualified to dance in that arena unless you have a legal representative, or at least there's no clear way that an idiot like moi can walk into that court and just try and lay a claim and present the facts to a jury. Because yes, we are all incompetent in a criminal court, but I'm not incompetent talking to 12 people and trying to prove my point, prove my case with the facts and evidence to 12 people. Hence, the jury system makes sense to me. I can talk to 12 people comfortably. I can present my facts to them, try and show them the strengths and the merits of my case, and have them decide on the truth. As they say, interpret the facts and the law before them in order to render a judgment, or render a judgment. So that's basically where the criminal law has a barrier to entry, in my opinion. If someone's done you wrong and the police aren't willing to help you, the CPS say you don't have a case, but you think you have a case, and you wish to obviously work against that inertia of what the state says they can't help you, the private prosecution or bringing your own action. There's definitely a barrier, in my opinion, to people being able to do that. And then you have to look, well, let's throw criminal law out the window and let's access the court system in the civil light. Now, if you go into a civil courthouse in England at the moment, you have public counters are pretty much all shut down. You have to pre-book a meeting somehow, which is done over the phone, and if you're lucky, even that they'll entertain giving you a booking. And if you do get that booking, you turn up, they're not prepared for you, which is in my experience. And then they won't again entertain any private claims being brought before, private actions, private claims being brought to court. It has to be the legal way or the highway. So then again, if you go in the legal way, you're surrendering your sovereignty by applying your words onto their paperwork, paying their fees, and now you're paying for their service. You've asked for that service, and therefore, hey, you get entered into a legal realm where you can't have a jury trial. You can't bring your facts and evidence to 12 jury members. Because imagine that in all debt situations in the Commonwealth. You imagine a debt situation coming before 12 people of the community, where a bank wants to throw out a little old lady or a single mum because she's behind in her mortgage payments. Yeah, they would never win, because the moral, well, they might win, if you got a shrewd or crude enough jury that applies the law, because you can never predict what a jury's going to do. But in a lot of cases, the juries say, look, yes, you have a contract, okay, yes, you are completely justified in throwing this old lady out the house, but morally, as a community, as a people, we can't do that to her. So you need to come up with, you need to work with this old lady to establish some sort of repayment vehicle, system, whatever, contract, agreement, in order to satisfy your debt obligations to her, or her to you, and to keep a roof over her head. Because throwing people out on the street because they've not paid a debt is pretty brutal. It's almost as brutal as sending debtors to Australia and halfway around the world because they've forgotten to pay their water rates. Paraphrasing. So that's basically my take on that. So we'll go on. We'll move on to the next stages. The access to justice. I mean, I burst out laughing. That's like, yeah, right. And I'm working on that. That's where all the doors are closing at the moment. This whole access to justice, to me, it's nice to talk about it, but in reality, there's, unless what would you say, the agency presented to the people in order to access justice is not the agency that you should be using if you know the law. That's my thinking. So in order to access justice, you have to go almost to the source and present it in a way that they have to oblige you, and then you can open up court, and hopefully then you might get the justice that is elusive to all of us at the moment, because obviously controlling the courts is the first objective of a corrupt system. Is like, let's make sure no one can stand against us, whether you're a mafia or just a corrupt bunch of money greedy sods, or some sort of political power that wants to have its own way and not have and get rid of its enemy.
The rule of law does not come about automatically, and without constant effort and maintenance, it cannot continue to exist or cannot exist as more than simply words on paper.
Now there we are. They're admitting there. I mean, in that little statement, they're admitting rule of law is constantly under threat. If it's not enforced, if it's not fought for, struggled for, strive for, rechecked and rebalanced to make sure that it's working as it should be, it will not happen. So it's like, it was almost in that respect, it's everyone's duty to fight that for that right, for that particular system, in order to make sure that they still have access to it, their fellow man has access to it, the state has access to it, because it's not about having it won over someone else. It's about having an equal playing field where everyone can access to it. So the state is not overburdening on the citizen, and the citizen's not overburdening on the state or his fellow citizens, for that matter.
Constant commitment is needed, not only by the judiciary, of course, but also by the two branches of government, the executive and the legislature.
The separation of powers is a doctrine of constitutional law referring to the division of government responsibilities into three distinct branches, limiting any one branch from exercising the powers of another. First, there is the legislative branch, Parliament, which is responsible for publicly enacting law and is accountable to the electorate for doing so.
Secondly,
see, that's what I don't like. They're saying here the only way that you're accountable for public law is being accountable to the electorate. So if you elect someone in, like, I don't know, let's say Jeremy Corbyn or Nigel Farage, whatever's popular right now, or even Donald Trump for you American folk out there, or that Canadian guy for the Canadians, if they decide to build a wall, for example, between Mexico and America, it's basically, he's got a 5-year pass, get out of jail free card in some respects, to basically pump through the legislation that he wishes to do. It has to go via Congress. I mean, Congress in America is supposed to make the laws, not the president. The president's basically operating the government functions. So, how is that accountable when you've got a 5-year, especially in England, it's a little bit more authoritarian. Once you're in government, it's a bit more, you can no one can really challenge you until those 5-year fixed term, is it fixed term Parliament Act or whatever they got. So they're saying this system of Parliament and electorate, you're responsible. If they don't like you, they'll vote you out, which is true in a respect. But you've got 5 years to rock the boat. You can undo a lot of stuff. I mean, people Democrats would say about Trump, he's undoing years and years and years of environmental issues, protections, coal, gas, fracking, all that stuff. He's undoing a lot of those legislations to inhibit those industries to keep the environment safe. So is that really an effective tool, just to say, oh, we'll vote you out when we don't like you? Yeah, so we're going to suffer. We have to suffer for 5 years? Not sure about that.
the executive branch, the government, which includes the civil service, the police, and the armed forces.
Right, the executive branch, the government, so that's the cabinet. The civil service, yeah, I mean they're the real unknown factor in the whole of the UK system. Is like you got this entrenched workforce that it's almost like, yeah, who's in today? Is it red, blue? What colour party is it? Who cares? We all got our jobs still, yeah. We don't have the access to what Trump can do, where he can just pick and choose and throw out all the riffraff and say, right, you guys are my new guys. There's none of that in England. The civil service pretty much remains the same. They run the country. They have all the power in the background, whereas all these parties come in and out, and who cares? The civil service remains. Now the army was mentioned here, which is interesting. So he's saying the army, the cabinet, which is the government, and the civil service are the executive. Now the executive is the Queen, in my opinion. Surely the executive is the Queen, because all of the below mentioned departments and functions are all relating to the Queen and her kingdom, and because this is all essentially her property, all done on her benefit. All these civil servants swear fealty to the Queen when they enter into a public office. So yeah, the executive, in my opinion, is the Queen. That's the whole point of splitting of the powers, that we don't have despot kings going around taking what they want from people who have been entitled to have something.
Without the executive branch, laws passed by Parliament cannot properly be implemented.
So there we go. So now they're saying, so Parliament and the government need executive to agree to their laws in order to enforce them via the police, the army, the Queen's royal assent. So that's essentially all these officers that essentially run straight through to the Queen as her guards or her soldiers, her police force. You know, they all swear fealty to the Queen, and the Queen has to give her royal assent to the nonsense coming out of Parliament in order for those laws to be enacted and then being allowed to and be enforced upon the people whom she serves.
Finally, last but not least, the judicial branch. The judiciary and the...
I'll just say my view on the judiciary is the judiciary has always used to be the king. The king would sit at court and make judgments. That was quickly got rid of because the king is essentially sitting in his own court. So the king's judgments became slightly like, hang on, you can't sit in your own court doing judgments to your own kingdom, on your own people, on your own matters, on your own influences and stuff like that. So that quickly became phased out, and the judiciary was created where people, I presume learned people, would sit and as judges, or judges is the wrong word. They would sit as umpires. I like to call these people umpires. So they would sit as umpires to the cases, so that they would overwatch and ensure that there was an even match. You know, facts and evidence couldn't be presented that were irrelevant or potential of influencing the jury's decision, and therefore they would ensure the balance that, you know, the justice was administrated in an independent and proper manner. As being independent of the tribunal, so that the judges would basically just, you know, sit down being bored and sleepy and just make sure that things were permissible that were permissible and things that weren't, or not permissible or improper, are kept out of the courtroom so that the jury doesn't get corrupted. Their decision isn't corrupted anyway.
Courts and the tribunals, through which the law is administered, through which all persons and authorities in the state are subject to the general law, and through which the rule of law is maintained.
The general law, and through which the rule of law is maintained. Now let's look at the general law. Yeah, this is a term I'm not familiar with, this general law. Let's just look at general. What are they talking about, general? I suppose we'll go back to the dictionary. Class. The general law would be affecting a class or a member, every member of a class or category. So again, that would be within a society. So so that maybe that's how that's broken down into the general law of the citizenry of a society, which would encompass all the people who've obviously got links to Parliament by rank, class, status, whatever. And then the rule of law being that which is the most basic, in my opinion, is the most basic of law, the Ten Commandments and the New Testament element of forgive and forget, move on, you know, that kind of stuff. But interesting. Let's go back.
The three branches are functionally separate. Parliament does not, for instance, act in a judicial capacity, nor does the executive. The executive, like anyone else, is subject to the law of the land.
So he specifically mentioned their law of the land, and again emphasising the fact that they separated the king's powers away from judgments, and they put in a load of independent judges who sit as king or queen because they are an agent of the king or the queen.
It would be unthinkable in the United Kingdom that a minister would attempt to influence a judicial decision. Conversely, the courts do not legislate or provide advice to the executive, except in some very limited circumstances, such as on the practical or technical consequences of proposed legislation.
I mean, this happens all the time. It's pretty much what the UK Supreme Court does, is they get judges in to sit around, review legislation, fine-tune it so that it is lawful and there's no holes in it that might result in law breaking, which results in claims, basically, and liability, because obviously they don't want to have to pay out fines for operation of government. So I would say the government works very closely with the judiciary, and the judiciary works very closely with the legislature. Bear in mind that they also print the money that pays the wages of the judiciary. So they have this phrase where the judiciary has to be seen to be independent, right? So as long as they're seen to be, and it appears that they are independent, and most importantly they act as though they are independent, then we have nothing wrong with the system. But obviously they're not truly independent, because they all filter back into the Queen's service, the money printed by the state, i.e. the Bank of England, and the fact that they're all, if you like, sipping out the same milk bowl.
The courts may and do develop the common law, but they do so according to established principle.
So now they're talking not about the common law, the law of the land, the common law of the English government, the common law of the legal society, the common law that's been established through the 800 odd years of this established parliament. Their case law builds up as it goes along, and they tweak it according to case laws determined by judges who sit on those government courts.
They do so subject to Parliament's power to enact statute to revise, to alter or to abrogate the common law as it has been developed.
I just want to look at the word abrogate. Give me a second, sorry. That abrogate was an interesting... Abolish by authority. Yeah, so abrogate. Okay, interesting. Now this is something I have an issue with, is the abrogation. They couldn't just say abolish or get rid of, they have to speak in some bullshit tongue. But anyway, okay, so there's a couple of laws that I'm looking into at the moment which are annoying me, because something that was abolished in the 1967 Theft Act on the statute book, they abolished, I've probably said this before in my videos, but I'll say it again, they abolished something called extortion. Extortion was abolished from the statute book and sent to the common law. Now, in my opinion, that what they're saying is that the statute book isn't going to be concerning itself, or at least let's say the legislature, in this example, the legislature is no longer concerned with the administration of extortion. And then later on, they also abolished barratry. So barratry has been abolished or abrogated, as we've just learnt together. So they've got that off the statute book. So the legislative part of government says, right, you know what, whatever, we're not looking into this. So where would you go if the government? Let's put it in more simple terms. If the government abolished off the statute book murder, killing of any kind, we're not going to deal with it. We're just fed up with it. We're not going to deal with that anymore in courts. What the hell would you do to get justice if someone killed a member of your family? And that is technically possible, that the government or the state will abolish murder. It is possible. I mean, they abolished extortion. So why it's feasible that they could abolish any law that they want, which means they're not administrating it. So where the hell do you go if someone extorts money from you? It's a crime not understood or not recognised anymore, in my opinion, to the legislature. So then obviously I'm looking into, that's where I am at, and I'm looking into like, well, hang on, I'm sure, and I think 99% of the people in this country would agree that extorting funds from anyone under a pain of, confiscation of property or bodily harm or some sort of threat, is extortion. And and if especially if it's coming from someone who's acting in a position of authority, whether it be a bailiff, a police officer, or a civil servant, or even someone who just doesn't like you, your fellow citizen in that respect. So this is the point I want to make, is so the legislation has abolished a crime, they're not enforcing it anymore. So okay, it's off their service, out of their hands. So whose hands is it in? Does it still fall within the judiciary's hands? Does that mean you have to approach the judiciary straight, off your own back, and approach them in a proper manner to let them see and recall that the fact that extortion is wrong, barratry is wrong, it always has been wrong, but obviously in recent times it's become hip and trendy to abolish these acts because, hey, extortion's good for business and barratry really helps the legal society make a ton of money. Interesting. I hope that's a bit of food for thought for you people. Let's move on.
The three branches of government, the legislature, the executive, and the judiciary, keep each other in check in making and implementing laws.
Yeah, they keep each other in check, but really it's up to the people to bring cases against wrongdoers, regardless of whether it's the legislature, the executive, or the judiciary have done you wrong, because all three of those can do wrong to the citizen, in their terms, the citizen. So if the judiciary does you wrong, where does the citizen go? If the Crown does you wrong, where does the citizen go? If the Queen, the police, or the army do you wrong, where do you go? If the legislature, if government does you wrong, do you think you're going to go to the government court and get justice in their own court? I mean, just look at Grenfell. They're sitting around waiting for justice. No, it's not going to come on their timetable, is it? You have to bring the case against the government. Hillsborough. I mean, you could probably go. I mean, I don't know all the suspicious dithering and delays towards justice of these kind of, where many people have died. But it's interesting that if you don't bring the justice, don't expect it to come to you. It's up to you to know the law. This is where the saying is, ignorance of the law is no excuse. Your ignorance is delaying your justice.
The legislature draws the broad lines, which the executive then puts into practice. Then the courts decide in the individual cases brought before them. This balance also means that the legislature can adjust legislation following a court decision, after which the courts may be asked to interpret the new law.
So they're admitting there that the legislation can be a pile of crap. They're admitting there that the legislation can be completely contrary to the law. And then obviously once that happens, they'd have to redraw the legislation to fine-tune it to agree more properly with the rule of law, if you like, the actual law, the law.
And to apply it within the limits determined by the Constitution. This is an ongoing process.
Yeah, this is ongoing because the written law, the legislative law, the written law, it comes about from a corruption of the times. Okay, so it's always coming in, new nonsense comes in. Like now, let's take drones for example. There's been a lot of stuff in the news about drones being flown over airports by morons who are just like having a giggle. They've got nothing better to do with their time. So, whether it is happening or not happening, it's obviously something that's being pumped out there. So they want to bring in all this new legislation about who can and can't have a drone, who maybe you need a license to get a drone, maybe you need a number plate for your drone. All this lovely creation of a Ponzi market will happen in order for you just to buy a robot that you're allowed to fly up and down in the airspace above your land. So, that's essentially how the written law works. But the unwritten law, which we all know, because it's unwritten, we know what's right and we know what's wrong, that has to obviously agree, the legislation has to agree with that. So where there's a conflict or where there's overlap between what they've written down and it's not actually quite lawful in its purest sense of it, then there's a bit of a pushback. Well, at least there should be a pushback by the common law in order to keep it in check. And that's something that comes straight out of a law book that I've got, is that the common law, the unwritten law, keeps the common law in check where it oversteps its bounds and authority.
Under the rule of law, no one branch has the last word. One crucial consequence of the structural and institutional separation of powers is that the branches can come into conflict with each other. This is, of course, a possibility that cannot exist where power is concentrated in a single set of hands. Courts, for instance, sometimes give judgments against the interests of the executive. Ministers lose cases before the courts. Judicial review of executive or local government action sometimes requires such action to be quashed.
Ministers lose actions. Ministers? I mean, I'm not aware of any ministers taking anything to court. Oh, maybe you're taking this is maybe where you sometimes see someone or other against the Secretary of State or the Attorney General versus blah blah blah. Maybe that's what they're talking about there.
This is the price we pay for our commitment to the rule of law.
Lord Bingham of Cornhill once stated, "There are countries in the world where all judicial decisions find favour with the powers that be, but they are probably not places where any of us would wish to live."
And there we are, a nice way to end the video. But I hope that kind of goes into some detail about what it is all about, the rule of law and the separation of powers and how a healthy functioning government should be operating. Yeah, but I mean, this is the SoundCloud. Have a little look, and by all means read in. It's got a few more things. I'll look into these, and if I find anything juicy, I will indeed share them with you. Peace out.